just like last time, I'm required each time to remind you that you do have the right to the assistance of a lawyer if you wish.
No, I would like to self-govern, and I stand on my paperwork.
Okay, so what we have today, you did file 4 written notices that asked for some type of relief, and we had adjourned the hearing to today for any argument on that. So the prosecutor has had a chance to review them. So, you say that you stand by the paperwork, and that's fine. I do have the paperwork in front of me. Is there any argument that you'd want to make on your behalf right now to me in support of those claims, or do you wish to just rely on the written pleadings you filed?
It is my wish to stand on my paperwork.
Okay. Mr. Radsbaum, do the people have any argument in opposition to those 4 notices?
Your Honor, I've reviewed the paperwork, and I guess while she may not recognize or honor the state of the law, I don't believe that there's any relief that's recognized under law that would allow you to dismiss this case against her based on what she's alleged in the paperwork. I fail to see it.
Okay.
Buckle up, guys. Today we're stepping into a courtroom where the defendant immediately makes her position clear. She does not want an attorney and insists she will self-govern. The judge gives her an opportunity to explain the paperwork she filed, but she chooses to stand entirely on those written notices. Then the prosecutor responds, arguing that none of her claims provide a legal reason to dismiss the case. The tension is building before the judge delivers his ruling.
All right. Well, Ms. Christensen, now I'm going to make a ruling on the notices, which I'm construing as some motion or request for relief. And I've got a written order that I'll enter. I'll read it at this point. Defendant, who at this point in the case is representing herself, has filed 4 handwritten notices. These notices appear to seek relief in one form or another. As to the first notice, defendant asserts that she is a woman and not a defendant. The court finds that Angela Christensen is both a woman and a defendant in this criminal action. To the extent her notice seeks relief, such relief is denied. As to the second notice, defendant demands that any man or woman with a claim against her appear and present such claim in open court. To the extent that this notice seeks to invoke defendant's right to confront her accusers, this court will enforce that right. However, the right of confrontation does not require the complaining witnesses to appear at all pretrial hearings, but only the trial or any necessary evidentiary hearings. So to the extent that this notice seeks to require the appearance of any complaining witnesses at all pretrial hearings, such relief is denied. As to the third notice, defendant asserts that this court lacks authority over her and that only her creator has that authority. Without gainsaying the authority of the creator, it can be noted that religious traditions commonly recognize that the creator has instituted human authority as well. In this matter, the people of the state of Michigan, through ratifying the 1963 state constitution, as well as its predecessor constitutions, have established this court and its authority. The people of the state of Michigan, through their elected representatives, have established laws that apply in this court. And the people of this county have elected this judge to serve in this office. And this court has subject matter over this felony prosecution and has personal jurisdiction over this defendant. Any relief sought by this notice is denied. As to the fourth notice, defendant claims that this court and the government exist only because she allows them to exist. To the extent that this assertion reiterates the proposition that our constitutional republic is founded on the consent of the governed, such proposition is axiomatic as a general matter. However, this proposition does not require that the government must obtain consent or permission from each individual person before exerting governmental authority over that person. Such an idea is nonsense and would result not in a constitutional republic, but in anarchy. This defendant's views would render all the criminal laws null and void, which is legally and practically absurd. Therefore, any relief sought by this notice is also denied. All right, so Ms. Christensen, all of the claims and papers that you have filed, I have found to be lacking in legal and factual merit, and I have denied any such relief. and I'm entering a...
That's fine. Can you please stop referring to me as a defendant? And I guess the next step will be, I guess I got to do the actual filing of the claims if you're going to deny all of those.
No, I don't know what claims you're talking about. You filed some claims or notice.
Here, the judge begins addressing all 4 of the defendant's notices one by one, and the response is decisive. He rejects her claim that she can separate herself from being legally identified as a defendant, while explaining the limits of a defendant's confrontation rights. He then directly addresses her argument that the court has no authority over her, explaining how Michigan's constitutional and legal system establishes that authority. Finally, he rejects the idea that government power depends on her individual permission.
Notices or requests?
No, I did not even file my claims yet. I did notices. I did not file my claims yet. I've been putting that off because I really don't want to have to file claims and ruin people's lives and ruin their jobs because they're not upholding my constitutional rights as a woman, not a defendant. I am a woman only. I, woman Angela. I, woman Angela. I, woman Angela. That's it. Not defendant. I'm not a defendant.
Well, you are. And
okay, in your opinion and legalese, yes, but I am a woman. So do we need to do trial by jury when we can do my claims and file my court with your court at the same time? Because that's going to be my next step, to file claims against everybody involved in this case. Because there is no verified claim, and complaints and claims are 2 different things. I don't want to file claims. I'm trying very hard, and I've been trying hard to not do that. But I guess if we got to keep going, that's my next step. And I will file proper claims with the proper people and the insurancing for the bonding. So I don't know what you want to do at this point. And I really don't want to have to do that.
So here's the thing. I am not going to relinquish my authority in this case. I'm not. All right. The prosecutor's office can dismiss the case. They're choosing not to. So that means we do have to go forward to a jury trial unless you want to plead guilty. All right. I'm also going to do is your ramblings here today and at previous hearings, and after I reviewed your written notices, it's clear to me that you have no concept of the legal and factual issues at stake. And
I would never know anything about legalese because I never went to school to do the legalese, so I don't understand that part.
Courtroom dispute becomes even more intense. After the judge declares her filings legally and factually unsupported, she pushes back and insists she should not be called a defendant. She talks about filing claims against people involved in the case and argues that complaints and claims are completely different matters. The judge makes the situation clear. The prosecution is continuing, so the case must move toward a jury trial unless she chooses to plead guilty. Her repeated interruptions only add to the confrontation.
All right, you're illustrating my next point, and you have no respect for the authority of the court. You continue to interrupt me and such, and file these nonsense claims. So I am hereby withdrawing my consent for you to represent yourself. I'm referring this matter to the Office of Assigned Counsel for appointment. So any papers you file in this case, I will reject because they have to be filed.
Well, I don't accept that offer, and I do not require you to give me any court-appointed attorney, and I will self-govern because that is my right. I don't want an attorney. I don't do legalese. I'm sorry. I'm not trying to be rude or disrespectful. I'm trying to be very decent. I stand on my paperwork, and I'll do the rest of my paperwork. I will keep doing it, and now I'm going to file my claims, so that's fine. But no, I don't need no legal counsel. I refuse that offer. I do not accept that offer. I'm sorry. With all due respect to you, I don't accept that.
Well, Ms. Christensen, it wasn't an offer. So we are scheduling this next for a docket call on February 14th at 10:30 in the morning. And I'll refer it to the Office of Assigned Counsel for you to have an attorney at that hearing. You are no longer allowed to represent yourself in this matter, and you will be in person in my courtroom at that date and time.
I'm sorry, but I cannot be there. I can do it via Zoom, and I don't accept that offer either unless you want to compensate me for my gas and my time, because I can't do that. I can't even afford to. Sorry.
Ms. Christensen, it's not an offer. I want to have you here because you've expressed such disregard for the proceedings. I want to have you here so you can meet your attorney. Ms. Christensen, stop interrupting me. It's not an offer. You will be here, or I will issue a warrant for your arrest if you refuse to attend in person. All right, we'll see you February 14th, or I'll issue a warrant for your arrest. You have a good day.
You have a nice day.
Subscribe for more real courtroom moments.
The judge says her repeated interruptions, filings, and refusal to recognize the court's authority show that she cannot continue representing herself. He withdraws her permission to proceed without counsel and refers the case for an appointed attorney. She immediately refuses, insisting she will continue on her own. When she also objects to appearing in person, the judge gives a final warning. She must attend or face an arrest warrant. Like the video, subscribe to the channel, and we'll see you in the next video.